advisor.
Just get
Get down to the end. We have, of course, a former magistrate judge from Eastern Texas. And there just earlier, to remind you, now he's at Aiken Gum, and he is a partner at Aiken Gum. And he's heading the firm's Longview, Texas office. He focused his practice now, of course, on patent infringement litigation. And while he was a magistrate judge, he presided over more than 400 civil cases, of course, the vast majority of which were patent infringement cases. And prior to his clerkship, he graduated from the Baylor Law School as the highest ranking student in his graduating class. Just next to Chad is Jim Harlan. Jim is the Senior Vice President and General Counsel at Xterra Communications. Xterra is a global telecommunication equipment manufacturer located in the Eastern District of Texas in Allen, Texas. As General Counsel, Jim is responsible for all legal issues, including issues related to patent infringement litigation. He has experience working as an in-house attorney for other significant technology companies, including both Siemens Corporation as well as Research in Motion. Jim graduated most recently with his MBA from the University of Texas at Dallas, and prior to that, he received both a master's degree and his law degree from Wayne State University. The fourth member of our panel is Doug Kubail. Doug is a member and partner of the law firm of Baker Botts, working out of its Dallas office. He focuses his practice on patent infringement litigation, and he's handled numerous patent infringement cases throughout the United States district courts, from California, I know, to Oklahoma, to, of course, Texas, South Carolina, New Jersey, and he's also handled cases at the U.S. Court of Appeals for the Federal Circuit. And he's successfully represented both large and small companies, as well as both patentees and accused infringers. He's been recognized as a Texas super lawyer multiple times, and he graduated magna cum laude from the University of Minnesota Law School. So thank you to all the panel participants in advance. I'm looking forward to your comments. So let's thank them. Okay, so I want to start the panel by indicating some results of my own research related to statistics and patent infringement lawsuits. So statistics related to filing of complaints have shown that for several years, patent owners have targeted the Eastern District of Texas. So statistics maintained by the Lex Machina database have shown that the Eastern District of Texas ranked first, second, and third out of all federal district courts in terms of the number of patent complaints filed there in 2008, 2009, and 2010. But not only that, dramatically more accused infringers appear to be named in cases in the Eastern District of Texas. So other statistics indicate that from 2008 through September 15, 2011, which was the day before the enactment of the American Vince Act, the number of accused infringers named in initial complaints filed in the Eastern District of Texas far exceeded the number of accused infringers filed in initial complaints filed, for example, in the Northern District of California. So my data indicates that while in the Eastern District of Texas there would be a mean of about 9 accused infringers in each case, in the Northern District of California the mean would be about 2 infringers in each case. So with those statistics in mind, Chad, my first question is for you. And I want to know, why do you think the patent owners target the Eastern District of Texas, and why do you think that there are relatively more defendants named at each case in the Eastern District of Texas?
Well, looking back historically, I think getting into 2000, 2001, patent owners obtained a series of pretty favorable verdicts. And if you're wandering around looking for a place to file your patent case, I think if you're a plaintiff's lawyer, you're going to naturally be inclined to file where you think the juries will be more receptive to those types of cases. And, you know, in East Texas, historically, Marshall, you know, had a reputation for what I would call plaintiffs-friendly juries. You know, we were in a defense practice over there primarily when I was in private practice, and it had a reputation that dated back, you know, frankly, to cases that have been filed against the railroad. So that forum, I think plaintiffs naturally thought of as a place where they might be able to get a plaintiffs-friendly jury pool. You had judges over there, as we talked about earlier today, that were not afraid of patent cases. And so, if you're an advocate wandering around with a patent case, wondering where to file it, I think you'd be more inclined to file it in a court that was willing to look at it as opposed to one that would, be more inclined to grant summary judgment or transfer the case elsewhere. With respect to the joinder aspect of, why more defendants are joined, I think that comparatively speaking, the joinder law in the Fifth Circuit and in the Eastern District has been more liberal. So the law allowed the joinder of more defendants than it might have allowed in some other districts, and we'll get into that later. But I think for purposes of efficiency and, possibly in response to some of the decisions from the circuit on venue, patent owners, if the law allowed them to join multiple parties as accused infringers and make a better case for venue in a location where they thought they would have a favorable forum, I think the role of the advocate was, naturally would cause the filings to increase and the number of accused infringers to increase.
Now, let me turn to Doug here. Based on your experience, before the new rules went into effect, as we know, joinder and consolidation are governed by the Federal Rules of Civil Procedure before the new act, and that was Rule 20 and Rule 42. So given your experience litigating patent infringement cases, how did these rules apply in practice?
Okay. Well, I'll address that kind of immediately before the AIA went into effect, but before we get there, it's maybe helpful to look back, say 15, 20 years ago, and I think back at that time, what you more typically saw is cases that were competitor versus competitor cases, and not so many of the non-practicing entities or patent trolls suing groups of defendants. So in those cases, to the extent that there was one particular competitor that had a patent that might be applicable to multiple different folks, I think what you more commonly saw was for there to be a suit against one of those competitors, either a competitor that was maybe viewed as a weaker adversary, or maybe one that had very strong ties to a particular jurisdiction that you wanted, and to get that case going against that particular defendant. And then as you got that case going and you started to develop an argument that now that court has knowledge of the patent, so there's a good reason to keep the case there, you might bring more cases than against other folks. And that was more typically what you saw in the past. And I think as we got into the early 2000s, we saw the advent of more cases being filed by non-practicing entities against multiple folks. We also saw, as Chad referenced, some decisions out of districts like the Eastern District of Texas that gave more favorable treatment to keeping cases with multiple defendants, whether you want to view it as because they were infringing the same patent, alleged to infringe the same patent, or because they were all kind of alleged to be doing similar things that were alleged to be infringing. It was relatively easier to keep folks in a given jurisdiction with multiple folks. And the My Mill case, Judge Davis's case in 2004 is an example of that. So you have this confluence of that sort of case law around the 2004 timeframe, and the non-practicing entities now starting to sue multiple groups of folks. We saw more and more that was becoming the norm. So you get up to the sort of the pinnacle of it the day before the AIA went into effect, the last chance to make these filings against multiple defendants, and you saw cases with 60, 80, 100 defendants in one case, all just alleged because they were allegedly doing the same type of thing to infringe the same patents. That's sort of the evolution of how we got up to the doorstep of the AIA.
Okay, and then, so I want to talk about, and Chad, I think you referenced this, the venue issue and choosing your forum, which is, it seems to be related here. So on the one hand, we have the new rules governing joinder and consolidation for trial. And then we also have the law related to transfer and inconvenient forum. So as we know, in the last, I think, 4 years or so, the U.S. Court of Appeals for the Federal Circuit has granted mandamus several times, directing district courts, including the District of Delaware, as well as the Eastern District of Texas, to transfer cases because it's in an inconvenient forum. So leading up to the legislation that we're focused on today, the legislative history behind the new act focuses, at least in part, on the Eastern District of Texas, although in the context of its precedent related to joinder, not necessarily related to transfer. But Jim, your general counsel for a company located in the Eastern District of Texas. You might be a plaintiff in one case, maybe a defendant in another, accused infringer in another case. Do you think the new rules are really about joinder, or are they just about venue? Is it a venue provision in disguise?
I think time will tell, but Doug and Chad sort of hit on a lot of the venue issues as well. It's sort of a funny thing because I think before the AIA, it didn't really matter, sort of where you were located, as long as there was that same patent that the entire group of defendants was infringing, that based on the MyMail case and its sort of progeny, that if you were brought into the Eastern District, there you stood. There were some exceptions, but then post AIA, I think one of the intents of that of it was to make it more difficult for the new entity, newly created entities, or whatever the term was coined earlier today, was to make it more difficult, but to sue multiple defendants. But what we've seen actually, I think, just looking at statistics of the filings after September 16th of 2011, is you'll have 30, 40 cases, same plaintiff, but the singular defendants in the same court, and they're not in separate jurisdictions, which is kind of interesting. I would think that you would maybe see, if a plaintiff were to sue 40 defendants, you would see 10 in one jurisdiction, 10 in another, 10 in another, and 10 in another, assuming equally distributed among 4 jurisdictions. But you don't see that, so it's almost like there's a muted effect so far. And I'm kind of curious, and I know we're going to talk about this later, but what impact judicial efficiency and economy is going to have on the discussion, and if in fact the whole the intent to make these NPEs filing cases against multiple defendants in a single jurisdiction, if it's just sort of going to go fall by the wayside. I just don't know yet.
Lisa, I want to ask you a question. And the American Invents Act, in this provision we're talking about, is the new 35 U.S.C. Section 299 related to joinder and consolidation. It's fairly unique in the respect that it's effectively reversing the federal rules of civil procedure, but not only that, it's doing it in the context of one particular type of litigation, patent infringement litigation. Why do you think Congress created a new special rule for this type of case?
Well, I think the best evidence of that is what Congress told us, or what the legislative history suggests, and it said that it was doing two things that are themselves somewhat contradictory, which is that it was codifying the proper interpretation of Rule 20, but its goal was to conform the law regarding joinder in patent cases across the land in accordance with the law in a majority of jurisdictions. So, and the reason I say that those two things are somewhat in tension, and I think there are enough interpretive issues around Rule 20 and Section 299, the new Section 299, to occupy an entire conference, but I think only someone who teaches civil procedure could say that. One issue, just to throw out one, is, okay, so if the goal was to conform the law of the Eastern District of Texas and any other minority jurisdictions with the majority of jurisdictions, does that mean that the law in the rest of the jurisdictions hasn't changed? Well, but that can't be, because the rest of the jurisdictions have Rule 20, which says one thing, and Section 299, which says something else, and they're different on their face. The language of the statute has to mean something. I mean, again, that's just an example of, I think, the kinds of trouble that we may get into here. It's notable because it is an example of a procedural rule that is aimed at a particular cause of action. And that in itself wars with the entire foundation of the federal rules of civil procedure, which of course are designed to promote uniformity and things like that. So I think there are, so I think we know why Congress told us it was doing it. But it's a remarkable step that has been taken with regard to uniform procedural rules.
So Lisa, you mentioned the changing in the approach in terms of a uniform rule versus a rule directed towards one cause of action. So other things that I've thought about in terms of the pleading standard or potentially just the discretion granted to district courts. The federal rules are very liberal in terms of granting discretion, relatively liberal in terms of the pleading standard. This seems to kind of go against that.
Yeah, I mean, I think that's right. I understand Rule 20 to be a rule that confers significant discretion on the district courts, and also, in fact, discretion to, it's at the instance of the parties. The parties may request joinder but do not have to in circumstances that satisfy Rule 20. So it seems to me that the new statute at least appears to be aimed to remove some of the discretion from the courts, and certainly to deprive some power from plaintiffs who would otherwise seek to join defendants. The big question is how much power, or in what circumstances, I think, does the new statute take away that power, or that option at least, from the plaintiffs.
Well, let's talk about that. So that really goes towards the question of how is the new rule different from the Federal Rules of Civil Procedure? We've been talking about the effect. Right. But Chad, let me ask you, so can you kind of compare the Rule 20 and Rule 42 approach, for example, with the new rule, and what's the new test?
Sure. I mean, the language of Rule 20, joinder is permissible if the two requirements are met, same transaction occurrence, or series of transactions or occurrences, and the common question of law or fact requirement. Under Section 299, persons may be joined as accused infringers if there's a right to relief asserted against them jointly, severally, or in the alternative related to the making, using, selling, offering for sale, or importing into the United States the same accused product or process, and there are common questions of law and fact involving each defendant. And there's a caveat in the statute that's explicit that says that allegations that the defendants infringe the same patent or patents in suit is insufficient to satisfy the requirements of the statute. So that's, I mean, essentially you've got to have multiple defendants making, using, or selling the same product or process, and common questions of law and fact. Simply alleging that only alleging that the same patent is infringed is not enough. And I was remiss a little while ago in my comments that Tom Jackson had some success prior to 2000 in patent cases in Marshall. He and his firm represented PI. Case, I think we held you to your prayer in that case, Tom, so it was a great experience getting steamrolled by y'all in that case. But it was a popular venue even before 2000, at least for some patent. Anyway, that's the requirement of the new statute.
Yeah, so the same accused product or process, we'll get back to that. I want to talk about how that might be interpreted and applied in particular cases. I want to highlight here, right, that the new rule not only applies to questions of permissive joinder, but also to consolidation for trial. So, Jim, I guess a question for you. Do you think this is a significant change? Do you think it's an important change, the change with respect to the test applied to determine whether consolidation for trial is appropriate?
Yeah, the consolidation for trial, that is 299B, I believe. And it's kind of interesting because you can then pull into the, 28 U.S.C. 1407 about multi-district litigation. There's a suggestion out there in the blogosphere and whatever it is that you read that despite the fact that there are multiple cases against multiple defendants and the same plaintiff, in the interest of judicial economy, that for all pretrial issues that they would be consolidated. Well, kind of a unique issue with patents is that most of the pretrial issues kind of go to the fundamental legal decisions of what is a patent, i.e. a Markman hearing. That's all pretrial. So, if you can get a case consolidated under 1407 under the pretrial guise, that and then get a single Markman hearing, so that the judge does not have to construe the same claim set or opposing claim terms or whatever it is multiple times, 40 times in some instances. I think that that's going to be kind of an interesting, I guess, outcrop of the AIA, and find out how much multi-district litigation does crop up. Hope that answered your question.
No, I think it does. So, and I think we'll return to multi-district litigation. I want to focus on that in some detail because I think it might be a significant effect of the new rule. And I want to go back to the interpretive question. So, the language, right? Same accused product or process. I think is subject to some interpretation, and I've done some research and writing in this area, and I think there are at least two interpretations, or probably more, but those are based on dictionary definitions of the word same, and whether same means the one thing under discussion, or if instead there's a different dictionary definition of same that means basically imperceptibly different. So they're two separate things, but they're imperceptibly different. So those are at least two interpretations I've come up with that might affect the application of the new statute. And Lisa, I wanted to ask you, do you have a view as to how same accused product or process should be interpreted, or what the significance is in that dispute over interpretation?
Yeah, I mean, my view is, and this is a view that, I have acquired over my years of teaching and writing in the area of civil procedure and patents too, but particularly with regard to procedural issues, that a healthy respect for nuance and a healthy respect for the interpretive issues that I think can come out of this kind of language. I mean, and I think part of it, we do have to go back to the legislative history and what Congress was trying to do here. Again, it said it was trying to both codify the law of Rule 20, the correct law of Rule 20, and follow the majority of jurisdictions. But a lot of those jurisdictions that were more restrictive, for example, interpreted the same transaction or occurrence language, which appears in both Rule 20 and the new statute, as being satisfied, for example, when multiple defendants had their own products, their own individual products, and those products had some differences, but they operated the same way, or they had a common component, or and that was regarded. Apparently, Congress wasn't unhappy with that interpretation, at least from its telling it from what it says in the legislative history. So that would lend support for the notion that same product or process could be, it isn't your first dictionary definition at least, doesn't have to be the one thing we're talking about, and would leave plaintiffs and courts with some room to interpret same product or process broadly. And that would also suggest, though, that the law in those jurisdictions hasn't changed, and that can't be, because those jurisdictions are now operating under a new statute that has lots more language in it and more requirements in it, as Chad said, than the statute that the rule that it used to operate under. So that's one aspect of this. Another possible interpretive issue involves standards, and when single plaintiffs include or accuse multiple defendants of infringement on the specific ground that they have incorporated the same standards technology or the same standard in their products. There's an argument that makes them the same product, or maybe it doesn't, even though they've not acted together other than in the context of the standard setting organization. There's even an argument that may be made that they are practicing the same process, even if they're not selling the same product, as long as the product operates in the same way in accordance with the standard. So those are just some of them. I think there are also interpretive issues just setting the two statutes, again, side by side, and trying to, and Dave and I were talking at lunch, I think there's an interpretive issue about outside of patent cases, has the meaning of Rule 20 changed by virtue of the fact that it is now different from the statute? But we'll confine our comments today to patent cases. Those are some of the things. Again, I don't know if I've answered the question, but.
Well, it sounds like there are a host of interpretive issues here. So, Jim, let me ask you, like I said earlier, you might be a defendant in one case, a plaintiff in another, but I'm curious to see if you have a view as to the better interpretation of the Section 299.
I may be a little more of a cynic than Lisa is, but sometimes I feel like our profession gets a little too hung up on it's kind of like, you know, back in the day when someone said, well, what is? You know, it's sort of the same. You know, you talk to a jury and it's the same product, you know. Are they the same product? You look at one, you look at the other. They both might be covered by the standards like, you know, 802.11. They both might be wireless devices. You know, one's a cell phone, one's a wireless access point. They both have Wi-Fi. Are they the same? I mean, you look at a jury and they'd say like, yeah, no, they're not the same. One's a cell phone, you can't call your friend off the wireless access point by Linksys. Conversely, you know, there's the case, the Crymar case that we sort of have discussed behind the scenes, and that's up in Delaware. And they raise a really interesting argument about the standards that Lisa brought up also about standard setting organizations and whether or not something is the same product. Well, you would think that if all these people are sitting down together and creating a standard that it should be the same, right? I mean, that's why we have a certain type of plug that we all plug our electronics into because they're standard here. They look the same. It looks like the same product, even though one's made by GE and one's made by, you know, Lucent or somebody else. So I'm wondering how, you know, that whole what is will be defined. What is same product or same process? How that will be interpreted. But over the ensuing months, if not years, it's going to be fun.
Well, could I
sure.
chime in one more thing about this? And I think this interchange illustrates the potential for interpretive issues. Another aspect of this has to do, I think, with just look at the new Section 299 on its face, and it has an A and a B, and the B says that that accused infringers may not be joined based solely on allegations that they each have infringed the patent or patents in suit, as Chad talked about. So the Act says that's not enough. But in A, it has these requirements about same product or process. And it just seems to me that, again, if Congress was aiming at just lumping people together because they are accused of infringing the same product or process, that subsection B would have been enough. But there's apparently there's an additional restriction put on by subsection A that goes beyond what just subsection B means, because they're sitting in the same statute. All the words of the statute have to be given meaning, just like all the words of a claim have to be given meaning. So that's, I think, another issue. If Congress was aiming at one thing, did it swing more broadly than it intended to, and what kinds of interpretive issues has it created as a result? But I acknowledge that, and I just think we're going to see some, and there's enough reason, I think, for the parties to litigate this a lot, the interpretation of the new statute, that we're going to potentially see some differing interpretations coming out from the district courts on these issues.
If I can follow up real quick on that. As I look at 299A1, where it talks about any right to relief, blah, 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 same product, same accused product or process, I can't help but think about something like the entire market value rule as being a right to relief, you know, in the damages context. How is the same accused product or process going to impact something like the entire market value rule or damages? If I just make the graphics accelerator on a Xbox 360, you know, yes, you know, people buy the Xbox 360 for its capability and its graphics, so there is an argument that the entire market value rule applies there. However, you know, if I'm involved in a lawsuit where you don't have the same accused product or process, and so the right to relief might be different, you know, is this 299A1 going to embolden the EMV or erode it? I don't know. I just sort of was thinking about that as Lisa was talking. I think that might be interesting to see. If there's any law students, write a note on that.
Well, Chad, as a former judge, so considering these types of situations where you have interpretive issues, what factors would predominate in the judge's view, analyzing, you know, how the new statutory section should be interpreted?
Well, one thing is for sure, whatever I say here, the courts will do the opposite. I suspect that judges' decisions will be driven by a couple of things. first thing is whether they resort to legislative history, I think. If they do, then as Lisa said, there's room for a more expansive definition, I think, of same product or process. And one of the cases that I'm aware of, joinders being attempted are multiple types of computers running the same software program, for instance. Same product or not the same product. There may be room for a more expansive view, more consistent with the jurisdictions in the majority rather, than for a judge who does not resort to legislative history. If the judge, if he or she looks at the statute just on its face, then I think there's room for quite a narrow view of what the same product or process is. I think the other thing that would drive the judge's analysis on how he or she would construe the statute, one thing you hit on earlier, is this venue regulation dressed up as a severance or a joinder issue. If the judge gets the idea that you're trying to end-run the circuit's decisions on venue in a way that's inconsistent with what that particular judge views as the purpose of the statute, then I think the judge has got a lot of tools to do a lot of things in his or her discretion, and that may influence the way that the judge approves the statute. So, I think those would be the two primary drivers, I think, that influence how the judge rules on a case.
Okay, let's talk about now kind of effects of the new statute, and I'm curious to see the different views as to what the effects will be. Someone mentioned earlier maybe an increase in multi-district litigation. Does anybody have that view and want to give your view on whether this is going to increase multi-district litigation?
I think it will. I mean, I think that's one of the things you're going to see happening, or multiple cases, depending on how the circuit or the courts come down on the question of if, for instance, you file serial cases on the same day in the same venue, if the defendants are eventually have the right to have a venue motion heard and determined independently of the consolidation issue, and if the cases are spread out all over the country, then I think you're going to see more MDL proceedings. One thing that people who are more familiar with MDL proceedings than I can answer is whether a Markman ruling in an MDL proceeding is binding on the judge that tries the case and instructs the jury, because it's a question of law, and sometimes Markman issues don't arise until you're in a trial, as all well known. And so the efficiencies, I think, that might be created by the MDL proceeding might eventually break down the closer, once the cases are transferred back to the originating courts. Because MDL, you don't have a right to a trial in the MDL court. It's just pretrial proceedings. So those are questions I think maybe this conference in a couple of years from now will have a better handle on it. But I think that you're going to see an increase in MDL.
Well, following up on your point about efficiencies, do any of you have a view as to whether this is actually going to create efficiencies or create inefficiencies in terms of the position? If there's MDL, is that really more efficient than having where the trials then would be in the different jurisdictions, and maybe there's some convenience factors associated with that for the particular defendants in those cases, as compared to kind of the old way that we had litigated cases, which typically was you'd have all the defendants in one case in one court, and maybe they wouldn't have, they could have been transferred if they were separate cases, but instead they're consolidated in that one court. Does this create efficiencies or inefficiencies? I'm curious.
I'm not sure if I can compare it to the MDL. It seems like the MDL compared to the old way would be fairly similar. You'd have a single judge consolidating everything. You'd have the defendants all in the same court, all consolidated discovery. It would be very similar, it seems like. There are definitely challenges for defendants with the new way of doing things now. Now you have, as Jim mentioned, you've got 40 separate cases filed on the same patent, oftentimes in the same jurisdiction. We see Delaware being a popular jurisdiction for that because most companies are incorporated in Delaware, and it's difficult for those companies, at least historically, it's been very difficult for companies to argue for transfer out of Delaware. Sought the benefit of Delaware for their corporate formation. Now they look at it for a venue for lawsuit. So as a defendant in one of those cases, you're faced with more difficult interactions with the other defendants. The joint defense groups that you might form, you have to make decisions of, do you want to argue that discovery ought to be consolidated anyway? Is the judge going to make you do that anyway? You might get some advantages because the things that other defendants get from the plaintiff, be it deposition testimony or documents, whatnot, flow readily to you. But you've got a disadvantage because you might want to keep evidence out with respect to another defendant in your case. If I'm in a multiple telecommunications providers case and I'm representing AT&T and we've got some sort of a consolidated discovery ongoing, I don't necessarily want something that somebody from Sprint said in relation to damages coming into my case, right? So there's a lot of moving parts that we're going to have to deal with that were maybe kind of already dealt for in the old way of doing it, and now we've got some choices in the new way of doing it. How much do we want to work together? And if we do, is it as easy as it used to be? It's probably not. So there are some inefficiencies and some challenges for defendants.
But do you think, just one of the things that I was thinking about, it's going to encourage the strategy of filing against, say, one defendant and waiting to file against other defendants?
Yeah.
I'm not sure, well, I'm sure that the ability to form joint defense efforts, common interest groups is being impaired by the new. Yeah,
that's sort of something I've been thinking about is maybe we'll see more of a return to the not so days of old, days of so old, but the days of older when the strategy was to pick a attractive defendant, get your case going, get the judge familiar with the patent, then bring in everybody else in the other suits and hope that the judge consolidates everything together. And it's very difficult for those folks to then transfer out because now you've got judicial efficiency arguments that you're going to make.
And maybe a Markman opinion that's adverse to what it would be.
Exactly.
For the other.
Exactly. Yeah. So as a defendant, if you're in the first wave, you've maybe got a disadvantage where other people can piggyback onto all the work that you've done and you've got to front all the bill for it. But as a defendant in the second wave, you're kind of stuck with the Markman that's already happened. Right. So it gets tougher for defendants in a lot of ways.
Right.
So we've been talking about efficiencies really with respect to discovery, but there's the second part of the new statute which affects consolidation for trials. So in thinking about that, it seems like it's going to encourage potentially multiple trials on the same issue. In patent cases, that would be invalidity. So that seems like to allow multiple bites at the invalidity apple. And Lisa, I guess, do you think that is right? Do you think that's a good thing, a bad thing? And efficiencies, inefficiencies, obviously some inefficiencies, but is that necessarily a bad thing?
Well, and I have a particular sort of worldview on this that I have to confess to. I mean, I don't like invalid patents in the marketplace. So, and this is why I've advocated liberal declaratory judgment standards and things like that. So, I mean, assuming the decisions are correct, if not, ultimately, whether at the district court or at the federal circuit, I think there is something to be said about the multiple bites at the apple, opportunity, that a reality that will be created by this. But, this whole, I agree with Doug that there's going to be all these trade-offs in terms of, and I think what's, for a defendant, it's going to be very challenging to know, not going to be able to foresee whether working together would be a good thing or a bad thing until perhaps it's too late to reverse that choice. So, but, I think that there's no question the new law prohibits consolidation for trial, which is, again, a radical change as compared with Rule 20.
So while the new statute may not allow consolidation for trial, it may still allow for, at least there's an argument, I think, that it would allow for consolidation for pretrial purposes. And I think, Chad, you brought up this point about, holding one Markman hearing. How receptive do you think judges should be to the request to consolidate, even though there are multiple cases that were filed, consolidation for pretrial purposes, including a Markman?
Well, I think most judges would do that even under the old law. I mean, if there's an opportunity to do one Markman instead of 17, then, I'm all for one, but that'd be my inclination. And I think if you give the parties who are in each of the cases the opportunity to be heard, then you've satisfied everyone's right to be heard. I don't know that I agree with, for instance, on the invalidity side, the multiple bites with the apple eliminates invalid patents. I mean, I think it has a greater likelihood to eliminate invalid patents because you're having multiple trials on the same patents. And I'm not sure that a patent is more or less invalid because it's tried in a jurisdiction that's more disposed to finding invalidity than one that's more favorable to patent owners. And so I see some real inefficiencies there for the multiple trial aspects, and to the extent that judges, I think, can decrease those by consolidating what they can, I think it is.
So even if judges would like to consolidate, I think there may be an argument that the new statute prohibits it, maybe? Does anybody have that view, that the new statute might prohibit consolidation for pretrial purposes?
Well, let me say preliminarily to whoever, I don't have a view on that, but I will point out that there are cases where courts have, even under the old law, have refused to consolidate, even for pretrial purposes, on the grounds that defendants have the right to make their own individualized assertions of their own individualized defenses, even if they, everybody's got an enablement defense. That doesn't necessarily, there's different ways of presenting and nuances there. So, that's been the case under the old law.
I'm actually seeing in my cases already that the judge is consolidating. It's the assumption there will be a common markman. You will work together on discovery. Yes, there's 12 different cases. You've all got your separate cases, and there's nothing being said about having any common trial at all. But, sua sponte, that's the way it's happening. You're going to have to step up and somehow lodge a challenge to stop that. That's what's happening right now. On the, as primarily representing defendants, I like the idea of multiple bites at the apple on the invalidity side. I don't know that we're going to see that. I think we're going to see arguments like, well, with respect to invalidity, it's one transaction. The patent was issued, one transaction, it's the same facts for everybody. We're going to have one trial on that. And then we're going to line, if you're not successful there, we're going to line you up and have your separate infringement trials. So I suspect we'll hear arguments to that effect. How that'll shake out, we'll see. But I would love to have separate invalidity trials in every one of these.
When you're representing the accused infringer. Oh.
Yeah.
Yeah. No, absolutely. No,
Chad points out, though, that
I'm not saying that's a bad thing.
Well,
As an advocate,
I would think from a judge's perspective, that's a bad thing.
Right.
That's clogging up the dockets,
Sure.
and these are common questions, and from many judges' perspectives, I'm sure we ought to have a single trial on these issues.
So I want to talk about strategies for patent owners with respect to their forum, right? So we started off talking about how the Eastern District of Texas is a highly sought-after forum. Maybe the legislature was trying to change the rules on joinder, maybe to affect choice of venue and to affect where the cases are actually held and tried. So I'm curious if anybody has any thoughts on, if you were thinking from the perspective of a patent owner, what strategies, in light of this new section, that you might take to maintain your chosen forum. And I'll just throw that out to the whole panel.
I think one of them is the one that we discussed here, that I would pick a defendant who has strong ties to the forum, who's not going to get transferred out, and I would start a case against that defendant. And once I got my scheduling conference and had some sort of substance where I could argue now the court kind of understands the patent, I would now file my suits against others and suggest to the court that there's enough room in the schedule where we can have a common Markman hearing. If we have to have 2 Markman hearings, we can put a lot of weight in the first one. So that's one strategy.
Dovetailing off of that, with strong ties to a forum, this is kind of my own personal, well, all these have been my own personal opinion, by the way, that don't reflect the corporation at all. In that I almost believe that in here there's a policy argument for technology companies that are subject to multiple patent infringement lawsuits to not be in Collin County. I know of a couple of companies in particular that have moved their headquarters into Dallas County because they didn't want to be in the Eastern District of Texas for this main reason. They didn't want to be in the forum already, and I know a company, for example, Huawei, that moved out of Dallas County into Collin County, and you're sort of wondering, scratching your head, is there somebody that is not at the helm of the patent litigation know what they just did? Because now they kind of, to support what you just mentioned, they are a target, that they're easily connected into the Eastern District of Texas. Their headquarters in the U.S. is now, or at least Texas is now in the Eastern District of Texas, and they have closest ties, so it sort of buttresses that. But I think that there's, and I've had this discussion with the Mayor of Plano, kind of talking about that, and kind of, he's had never heard of this before. So I think, and I've shared this discussion with other general counsels. I know of a couple, like I've said, that have moved out of Plano into Dallas for this reason. But it's because they're in a litigious industry that are subject to the newly formed entity pursuit.
I mean, there is Federal Circuit law on these factors that the more experience a court has with a patent, that weighs in favor of consolidation, and the longer, and arguably potentially against transfer, because the convenience of the court, or the court, is a factor in the transfer analysis as well, as does the length of time that has passed. So, 6 months, assuming the court has been active in dealing with the patent, would militate against transfer and in favor of consolidation. And I think the statute is consistent with the rationale that consolidation for pretrial purposes I read it as being, is encouraged. I mean, in other words, the notion to new 299B says that the mere fact that defendants have all been sued under the same patent is not enough. And so, in that effect, the statute makes the same patent irrelevant for joinder and for consolidation for trial purposes. But for pretrial purposes, it, by its silence on that, leaves it perfectly, I think, acceptable for consolidation for pretrial purposes along the same rationale that the courts have already developed. But I'm interested to hear what what the argument is for interpreting it as barring consolidation for pretrial purposes.
Well, I think there's a view out there that, what does the statutory language mean in terms of joinder? One approach is consistent with the view that it's permissive joinder. That's an action taken by the parties when they name a party in a lawsuit. They join multiple accused infringers in one complaint. They name them in a single complaint. Another idea, I think under Rule 42, the word joinder is actually used with respect to what the judge does when the judge actually combines parties into one lawsuit. So I think an alternative interpretation, not necessarily correct in my view, but is that, when it says joinder, they're not just identifying what parties can do when they choose to name accused infringers, but they're also affecting what judges can do in terms of combining accused infringers into one trial. So I throw that out there as a possibility, and I'm curious if any of you have a view on that. You don't have to have it.
Well, in some cases, it certainly would be helpful not to be lumped in with everybody else for pretrial, for the Markman in particular. Oftentimes, you're in a case where the normal thing to do is to form a joint defense group. Form a joint defense group, and 6 months down the road, where you're really getting down to what are the claim terms and how are we going to interpret these, well, there's some differences between how the products work and different interests. And we'd like to construe it this way, and they'd like to construe it that way. You especially get into trouble where the court has rules on how many terms you can interpret. So now you're down to a handful of terms that you're even allowed to bring up in the first place, maybe 5, 10. And these are very important to us. These are not important to us. These actually hurt us. And so what are you going to do? Are you going to argue to the court, well, you shouldn't consolidate this because we have divergent interests? Well, now you're kind of inviting, would you like discovery of all the joint defense communications because there was no common interest? So it's a difficult, another sort of difficult spot here. I think the resolution usually is that the joint defense group works together and finds the best middle of the road position they can that works for everybody, and just live with it.
And one aspect we haven't mentioned, right, is that under the statute, the accused infringers have the option
Yes.
to waive the heightened requirements. So I'll throw the question out there, do you think that will happen often, or are there certain situations where that's more likely to be appropriate and that accused infringers would do that?
I think it depends on whether I think there's going to be an advantage from doing so. Judge Davis, for instance, has procedures that he's used in some cases where you have multiple defendants. Demands on each defendant are relatively low, where he will accelerate your Markman hearing and invite early summary judgment motions. If you're in a situation where you had a case that could be resolved on a 1 or 2 term abbreviated Markman, that there would be, I think, a reason for the defendants who are all joined together to maybe forego splitting everything up and to transfer all over the country. I mean, that's one instance I think comes to mind. But there, I think depending on type of case and whether they thought that there were advantages by being joined together, I think that would drive the decision. So I think there are situations where you might waive, could at least consider waiving protections.
Certainly for the smaller companies in a case that otherwise would be able to coattail on to the big boys.
Yeah.
You got to make this, you got to think about this pretty early on, though, right?
No question.
You're not going to be able to wait around.
No, and that's, when do you, what is waiver under the statute?
Well, right, is it express waiver, is it?
Implied?
Implied waiver?
Participation in the case, like an arbitration clause. I don't, there's all sorts of things.
Well, I think we've raised some significant issues and questions with respect to the new Section 299. I at least wanted to briefly address some of the other aspects of the American Invents Act that affect patent infringement litigation, and there are a few. Right, so one is the change to the false marking, the ability to bring false marking cases. So, Chad, I wanted to just ask you if you could just describe the change with respect to bringing false marking cases.
Sure, there aren't any. There were a ton of false marking cases filed, a lot in the Eastern District, but really all over the country in response to a Federal Circuit decision that essentially held that marking product or product packaging with a patent number when the patent had expired constituted false marking. So to the extent you had manufacturers selling products but they weren't policing those patents that had expired, there's a potential claim that could be brought by essentially anybody as a type of a ketan suit to recover penalties for false marking. Well, that became kind of a cottage industry, and Congress took that away by limiting it to competitor-type situations, essentially amending the statute to provide that simply marking a product with an expired patent didn't give rise to false marking violation. So it really restricted the range of claims that can be made under the false marking statute.
So I just want to, highlight these topics, and if you guys have any questions related to them, we can get in more detail about these topics. But just to highlight some of the other changes. So, Doug, there was I think one of the panel members earlier mentioned the elimination of the best mode defense in litigation. Kind of a strange thing. The best mode requirement still exists at the Patent Office, but it doesn't exist in litigation. Do you think this is a good thing? Do you think it's going to have any real effect on litigation?
I'm not sure that it'll have too much real effect. The best mode defense is one that's very hard to prove, proving the subjective state of mind of the inventor that he or she knew that this was the best way of practicing it, a way that was not disclosed to the Patent Office. Very difficult to prove, very seldom used, and so it was abrogated as an invalidity or unenforceability defense. So some have suggested, you just pointed out, but it is still a requirement at the Patent Office. Section 112 of the statute still requires that it must satisfy the best mode. So could you argue that by failing to disclose the best mode, now you have unclean hands? Some other equitable defense that would prevent you from enforcing that patent? That it seems probably far-fetched, given that Congress said, well, it's not an invalidity defense, and don't try to backdoor it as an inequitable conduct defense either. Probably unlikely that we'll see.
I was just wondering, do you think it's admissible at trial, the failure to comply with the statute on just general
I can't imagine that.
credibility?
It would seem that the prejudice would outweigh the probative value. What would it be relevant to the case? I think the question case. Would you admit it?
Probably not.
I mean, it seems so prejudicial that
depends.
the jury's going to hear.
I mean, we tried to keep out, evidence that went solely to a claim of inequitable conduct, for instance. We tried to take that away from the jury and try that to the bench because this representation's
Right.
could be prejudicial. And I think that the failure to comply with, a 112 requirement that's been removed as an issue in litigation, I think you'd be a little bit of a buzzsaw to start thinking, is it?
Or even get discovery on it.
Right, unless it went to an equitable defense,
Right.
like unclean hands or something, get it there, but then it wouldn't come in front of the jury.
Well, another change, or at least a new aspect of the law, is the effect on the advice of counsel defense, or the effect of using the advice of counsel defense in respect to a claim of willful infringement. So the American Invents Act includes some a new section on that. Is this, Doug, I'll ask you to stick with you, is this just a codification of some of the recent cases we've had in the last 5 years or so on, the advice of counsel defense and its use at trial? Or is there some difference?
I think there might be a difference there. Under the previous law, you couldn't use the lack of an opinion as evidence of willfulness. You couldn't draw an adverse inference from it. But you certainly were allowed to admit the evidence and argue that in the totality of the circumstance, jury, you should just consider that sometimes people get opinions of counsel, and these guys didn't. You're allowed to consider that. You can't do that. So it is a meaningful change.
Okay, meaningful change. And then one other aspect of the law that was discussed earlier in the context of whether it's a meaningful change is supplemental examination and its effect in litigation on whether there's going to be a claim of inequitable conduct. So Jim, do you think this is a significant change that will affect litigation, the availability of supplemental examination?
Well, after TheraSense, it's just, I kind of agree with the panelists this morning that it's going to be, I don't think it's going to be used that often, to be honest with you. I don't see a lot of corporations, at least, kind of, going back and then kind of correcting something that they just didn't know about, or if they knew about it and they're able to correct it, that's one thing, and then I don't know. I don't see it being used that much. I know, like in other corporations that I've worked at, it's sort of, once it goes through the path, once the patent gets into the stream of the process, it sort of goes its way. And and you and engineers and everybody else, you're all working on the next thing. And then so as those things sort of fish off or go about their way, they're occasionally reviewed by patent committees for their value to the company. Are they still relevant? Do they still apply to product, or all that stuff? But I don't think there's anyone in the background going, there's some engineer who may not know that they should have disclosed that unless they're properly educated by their in-house IP team. I don't know. That's one of those things that I was actually noodling over for a couple of days, because I was trying to at least come up with a scenario when in reality would a corporation, a big company, do that. Because like I had mentioned, big companies have their processes. Would this would be something they'd have to actually put into their process, versus a small company, sometimes you're trying to put out all the fires. Is this something that gets on your radar screen because you've got 8 other things going on? It's just one of those things that I don't know how often it'll be used, and I think time will tell.
Unless you're getting ready to sue, right?
Well, there's some truth to that too, unless you're getting ready to sue. So, yeah.
The one place that I've thought about that, not so much in terms from the company's perspective, but if I'm a patentee's lawyer and I'm looking at a case where the other side has put together invalidity contentions like we all tend to do. So what I mean by that is what we tend to do in invalidity contentions in the cases where we have to explain why, as defendants, we think the patent's invalid, we tend to throw in the kitchen sink. And that means not just all different defenses, but all the prior art we could ever possibly think of. And of course, you're rarely of the opinion that you should lay it out with the very best one at the front, put it in alphabetical order or something like that.
That's the
Don't make it easy.
Yeah.
So as a plaintiff, maybe I'm sitting there with 400 pages of invalidity contentions that, you know, are pretty daunting. And I've got an option where one thing I could do is submit that to the patent office a few months before trial. And the patent office has 3 months to act on it. And unlike a regular re-exam where it's all laid out nicely and the very best reference is mapped out for him, and all he has to do is say, yep, I agree. The claim is rejected because of that. Now he has to wade through 400 pages and find, is there some reference that's really good in here? So I think we ought, as both sides should think about it, but certainly as defendants, we ought to think about in our invalidity contentions, maybe you ought to have Exhibit A, which is these at this time are believed to be very strong references, and Exhibit B, these are good references as well. But, you know, somehow get them out there. Another thing you can do, I suppose, as a defendant to get ready for it is get a request for re-examination ready so that if the plaintiff does submit that stack of 400 pages to the patent office, you can right away file a request for re-exam, which does have the nice mapping of the very best reference for the patent office. So that's one situation where a gambling plaintiff may try to do that and say, patent office might just let the 3 months pass and say, all looks good to me.
Sure.
And then all of a sudden, all the prior art is blessed by the patent office.
And Doug, one aspect of that in the, we're talking about supplemental examination, the current rules and the regulations that have been issued don't appear to require that the submission of the prior art for purposes of supplemental examination relate at all to a claim of inequitable conduct. And so,
That's right.
in fact, it's fairly unlimited in scopes, which creates this type of gaming of the system that we might see. So the last aspect of the American Men's Act I want to highlight is the Federal Circuit jurisdictional fix. So Lisa, if you could address what Congress did with respect to the Federal Circuit's jurisdiction.
The Congress abrogated the rule in Holmes Group versus Renato, which, and in so doing, expanded the jurisdiction, the appellate jurisdiction of the Federal Circuit. The Supreme Court had held in Holmes that the Federal Circuit did not have jurisdiction over appeals unless the district court's jurisdiction was based on arising under jurisdiction. In other words, the well-pleaded complaint rule, students in the room, you didn't think it mattered, but it does. The well-pleaded, unless basically the patent owner's complaint was the basis for jurisdiction. And so if there was even a compulsory counterclaim that came up in a suit, for example, by a trade dress plaintiff against a defendant who then countersued for patent infringement, the Federal Circuit did not have jurisdiction over that appeal, which resulted in patent appeals going to other circuits, which of course is inconsistent with the entire purpose for the creation of the Federal Circuit. So Congress changed the language of the Federal Circuit's jurisdictional statute in the AIA to add, in addition to the old style arising under jurisdiction, that the Federal Circuit shall have exclusive jurisdiction of an appeal from a final decision of a district court in any civil action either arising under or in any civil action in which a party has asserted a compulsory counterclaim arising under an act of Congress relating to patents. Interestingly, it also, along the way, made a related change that affects the interaction between the state and federal trial courts in this regard. The Congress provided that no state shall have jurisdiction over any claim for relief arising from under the Patent Act, and added a new removal section which authorizes removal of a civil action from state court in which any party asserts a claim for relief arising under the Patent Act. And so, and interestingly, any party can remove, not just defendants, so in those situations. So basically reinforced the lack of state court jurisdiction over patent claims and expanded the appellate jurisdiction of the Federal Circuit.
Well, I want to open it up to questions. We'll start.
I just want to ask a question on, recently there have been a number of cases on the malpractice side.
Yes, yes.
And had some varying results of whether or not those are proper state things or Federal Circuit, whether those are being district because of rising out of the patent.
Mm-hmm.
What's your thought on that? A recent case came out with criticism of court having
Yes. Yeah, I mean, the law, these malpractice cases, you know, it's the Federal Circuit saying that where, and I can't remember the exact language of the Federal Circuit's case, but basically where it's a issue unique to patent law. It's that same sort of rationale that if it's a malpractice case that's filed in state court, that sued lawyer or firm can remove to the federal court if it can convince, well, it removes, and then of course the plaintiff would try to remand down to state court, and the issue at the district court would be whether or not this is an issue unique to patent law, so that needs to stay in federal court. And so that's the whole issue in these cases are which issues, when does an issue fall on which side of that line? And things like, you know, blown deadlines, they don't seem to be unique to patent law. Whereas things that go to whether or not a particular patent claim should have been asserted and wasn't, or, you know, cause of action should have been asserted or wasn't, would tend to be something that might call for interpretation of the patent and therefore be an issue unique to patent law. One thing, it seems that these changes that I just talked about will make it, will tend to make it more likely that these malpractice cases will be properly held and heard in federal court and not heard in state court, arguably. But
there's a concept where we talk about for settlement,
right.
breach of that settlement, of course, frequently say, oh no, that's just a breach of contract, even though it's about patent. Doesn't necessarily, you know, not broad enough to say arising out of the patent, where in many cases the malpractice is very similar. It's right.
Well, you're preaching to the choir, because I actually think the Federal Circuit, a lot of the Federal Circuit's jurisprudence on what constitutes an issue unique to patent law, and therefore the Federal Circuit ought to apply its own law instead of the law of the jurisdiction where the case would. I think the Federal Circuit has generally gone way too broadly in that regard. So.
One more comment. Senator Mayali's on a crusade that two opinions recently. Very powerful writer. It's clearly dressed for it. There's a very good chance at some point in time, not this term, at some point, for very.
And the malpractice cases? Or,
yeah, jurisdiction.
Yeah.
Do we have any other questions for the panel? Okay, I think we're out of time, and I really want to thank the panel, and it's been very informative and fun, so thank you.